Jack Smith is getting ready for his blockbuster trial against Donald Trump, his 4-count indictment in front of Judge Tanya Chutkin this March of 2024, March 4th to be specific. And how do we know he's getting ready? He's filing motions, and he's doing the kinds of motions that you would do as you're gearing up to start trying a case. So today he filed a motion. It's called Government's Opposed Motion for a Fair and Protective Jury Procedure. So this was his motion saying he wants to do jury selection a certain way. He wants to be efficient, and he wants to be fair to the jury and protect the jury. And so that's what this motion was for. It's titled Opposed Motion, which basically means it doesn't have the consent of the defendant, Donald Trump. So Jack Smith and his lawyers, they asked the defense attorney, do you agree with this motion? They said no. So it's how they tell the court that the motion is opposed. It's not consented to, or it's not agreed to, or unopposed is how it would probably be said. And so just telling the court, look, you're going to need to set a date for their response to this motion because we don't all agree. So this motion basically starts out saying, Judge, just to keep things moving along and to be very efficient, why don't we use a jury questionnaire? And jury questionnaires are things that are done in cases that are typically either high profile or really big cases, or cases where they think it's going to be a little bit challenging to pick a jury, where they'll have to call in more people than usual, and more people will be disqualified than usual. And you can anticipate that in a case like this or in any high profile case. And so you can ask a judge for a jury questionnaire, because that way what happens is you send out a bunch of questions, they come back, the jury answers those questions, and then you can go through the questions and weed people out through the questions without having to go through the painstaking process of questioning them if there are certain things that will knock you out of being on a jury. So it could be things like, do you have a physical disability? Are you hard of hearing? Do you not speak English? Things like that could potentially knock you off the jury. Other types of questions, though, are more substantive that could disqualify you from being on a jury. And those are the types of questions that they will try to ask and put in the jury questionnaire. And so there aren't any formulaic jury questionnaires. I mean, there are the kinds of questions like the ones I just said. But then when it comes down to the actual case, they typically will make it specific or unique to that particular case. But it does streamline things. It does save time. And it is something that I've done as well in a couple of cases. And I do think it is very helpful. Now, let's talk a little bit about what voir dire looks like in federal court, how it's different than state court or some state courts. Because, for example, in New York, where I practice and have practiced my entire career in state court, the parties, the litigants, the prosecutor and the defense attorney, they get to ask questions of prospective jurors. You get to do voir dire where you are asking questions of the jurors, right? And things that you want to say, that you want said, to find out if the person can be fair to your side or not. But in federal court, the judge does all the questioning. The lawyers don't get to question the jurors. So it's very interesting because if you have a specific question that you want asked, you can ask the judge whether they would consider asking that question on your behalf so that you can get the information that you're looking for in that case. But in this particular instance with the jury questionnaire, that's your opportunity potentially as a lawyer to get certain questions put in the questionnaire so that it gets asked of the people. And so what Jack Smith says in this motion is that, look, Judge, you have the discretion to do a jury questionnaire. They're good for large numbers of cases or large prospective jurors to be screened, because there's so much publicity here. And by the way, it was done also in this very jurisdiction in many of the Jan 6 prosecutions, including the Proud Boys. So they cited to that as well in their motion, that there's precedent in this particular type of case. Also that, it allows the parties to prepare and propose these questions. And Jack Smith also proposed a schedule and said, Judge Chutkin, we propose that you order us to draft proposed questionnaire. We'll confer with the defense and we'll file a proposed one and indicate which questions we agree on and which ones we do not. The court, then, of course, you'll decide what the final jury questionnaire would be. Then we propose that the clerk issue jury summonses in advance of the trial, have those prospective jurors fill out the forms, something like maybe 3 weeks before. They proposed February 9th, 2024. Again, there's no magic number here. It's just that's what Jack Smith thinks this would take. And so before they do an in-person jury selection, they fill out these forms. And then on Monday, March 4th, when jury selection is supposed to start, we'll be ready to go. They also propose that the week of February 26th, the parties would jointly submit a list of jurors that they agree should be struck for cause based on the answers to the questionnaire, as well as ones that they don't agree, but that they also want, each side wants stricken for cause, and then they could argue with the judge. Now, what is to strike a juror for cause? So there's two types of challenges that a lawyer can make for a prospective juror. It's called a challenge for cause or a peremptory challenge. Now, a challenge for cause means you are saying, based on the answers that a juror has given, they are not qualified to sit in this particular case. So it could be, for example, in this particular case, it could be answers to the questions on the jury questionnaire that says, I can't be fair and impartial towards the government because I think the government has weaponized prosecution against Donald Trump. And so anything they bring, I will view as something that, is not really, I can't look at the evidence because I just think this is a political persecution. That person would get stricken for cause because they can't listen to the evidence fairly or impartially. Similarly, if they come in and say, you know what? I hate Donald Trump. I just think he's a criminal. He's guilty. No matter what, I will vote I think he should go to prison no matter what. So, and even if he didn't do this, he did something else. So I'm going to convict no matter what. That person would be stricken for cause for the similar reason. Now, what's harder though are the closer calls. And those types of cases, I think situations are ones where the parties would agree, yes, that person should be stricken for cause. But the harder calls are the closer calls, which are the ones where they might equivocate or they're not sure, or they'll express certain views but still say they can be fair and impartial. Those are the trickier ones, and so that's where you would ask other questions of the juror to try to tease that out. Now, the other type of challenge that you can give to a prospective juror is called a peremptory challenge, and each side gets a certain number of challenges that they're allowed to do just because, and they are able to, I'm not sure how many each side will get in this particular case, but it could be anywhere from 10 to 20. Depending on the charge, depending on the level of charge, etc. So in this particular instance, as I said, they'll have a certain number of peremptory challenges, and you can exercise those challenges for whatever reason you want. However, they can't be racial. So you can't say, you know what, I don't want Black people on my jury, or I don't want Asian people on my jury, or I don't want, things like that. That's actually illegal to do, and you can get challenged, and you'll have to give race-neutral reasons for why you picked that person. It could be, well, I saw them reading a book on their way in, and it was Mein Kampf, the Hitler book, and so I don't want that person on my jury, that kind of thing. You have to have some reason that is neutral like that to overcome that kind of a challenge. So basically, the other thing that this motion that was filed by Jack Smith's team also said, Judge, there's something else I'm asking for with jury selection, and that is you need to protect the jurors. The court, if you agree to the questionnaire, we will obviously learn the identities of the prospective jurors in advance. But you know what, Judge? You have to please impose restrictions to shield the names and identities of these jurors from the public. So the parties shouldn't be able to refer to them by name, only by number, like prospective juror number 25, et cetera. And you can't give any sort of, any kind of identifying information in any public record to protect their identity. They also talk about, doing research on jurors. So when you have a questionnaire, you have names, certain demographic information, and lawyers will often do some research on who these individuals are. And so Jack Smith's team is also asking the court to put some guardrails on that and only allow both parties to look at open source information. You can't communicate, for example, like you can't even like a photo or ask to follow them. That could be viewed as an ex parte or, a single-sided out of court communication with a prospective juror. So, so those are the types of things that Jack Smith was asking for and, pointed out and reminded the court and reminded everybody that, look, jurors aren't celebrities. They aren't public figures. These are just good citizens trying to, to do their job and do their civic duty, and they shouldn't be subjected to harassment based on having their name revealed in a court case such as this one. And I thought there was a paragraph that I just want to read to you that I liked from the motion, and it said, there are good reasons in this case for the court to impose these restrictions and enforce the district's standard prohibition against publicizing jurors' identities. Chief among them is the defendant's continued use of social media as a weapon of intimidation in court proceedings. In addition to the record before the court from the government's previous filings, just last week, the defendant escalated his conduct and publicly attacked the trial judge's law clerk in his pending civil fraud trial in New York State Supreme Court. The defendant did so by reposting on his Truth Social account, which has 6.4 million followers, a photograph of the law clerk and a United States senator with the baseless caption, "Senator's girlfriend," and saying the senator's girlfriend is running this case against me. How disgraceful. This case should be dismissed immediately. So that's the quote that Trump posted. Then it continues on. It says, as a result, the judge in that case was forced to issue an oral order that no party speak publicly about members of the court staff, given that the defendant, after apparently reviewing opposition research on court staff, chose to use social media to publicly attack a court staffer. There's cause for concern about what he may do on social media research on potential jurors in this case. It is therefore necessary for the court to employ the limited restrictions described above, even before the defendant's most recent concerning conduct threats to the court and grand jurors in Georgia. They also cited that there was an anonymous jury in E. Jean Carroll, and the judge there, Judge Kaplan, said keeping jurors' identities secret even from the parties upon finding that in the context of the defendant's repeated attacks on the courts, judges, and various law enforcement officials and other public officials, and even individual jurors in other matters, if jurors' identities were disclosed, there would be a strong likelihood of unwanted media attention to the jurors, influence attempts, and or harassment or worse of jurors by supporters of Mr. Trump. So very, very strong motion, basically showing that the government is looking at all of the cases, all of the court cases, not just this one particular court case, including civil, including state court, and saying, look, this is a man who threatens people, and this is a man who can put people's lives at risk and at danger with, and doesn't even blink an eye. And so therefore, this is how we should conduct jury selection. So stay tuned. Jack Smith is ready for trial. Jury selection is going to begin before we know it. I'm Karen Friedman Agnifilo with Legal AF. Join me and my co-host Ben Meiselas and Michael Popak every Wednesday and every Saturday on the MeidasTouch network. Join us, follow us on every kind of social media, and thanks for listening.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.